Good afternoon. This is not legal advice. Gently press the like and subscribe button if you like the content. It's 100% off all items on the website today, and each item is 100% off. So 100% of the items, 100% off. It's also Green Turkey Day today, and the first person to email me a green turkey will receive a fully certified golf clap. Today, I'm going to address Tesla litigation involving the direct sales dispute involving Tesla selling directly to consumers in various states. A lot of states have models that are set up as franchise models where there's an independent third-party dealer that gets between the manufacturer and the consumer. Many states that have these protective measures for franchises say they're also protective of consumers. Most states do have some restrictions on either sales or service. There are other ways around some of those issues. Some states limit the number of galleries or showrooms, but some states, like Louisiana, for example, basically outlaw all direct sales from Tesla per a 2017 state law. Cars there can only be sold through independent dealers, and like in Texas, you have to buy a car out of state and then ship it back in. This may be a way of either attacking Tesla directly, protecting old industries, or labor unions, or other reasons. But the bottom line is dealerships make money on service, so what's the need to promote EVs where less service is required? It should be noted that in some jurisdictions outside of the United States, they don't have these particular restrictions, so they are unique to the United States. Tesla's basic premise is that third-party dealerships can't properly disclose the advantages of electric cars for obvious reasons, as I stated above, the service model. And Tesla can't rely upon third parties to sell their vehicles to consumers. Moreover, they cite a 2020 Goldman Sachs report that showed that where direct sales were undertaken, that consumers saved nearly 10% off the gross sale price. This was contrary to a 2014 report commissioned by dealers that showed that franchise models provided a better value to consumers. There have been independent investigations by Consumer Reports and Sierra Club evaluating the competency and activities of third-party dealers with regard to electric vehicles. They have found they don't do an adequate job explaining electric vehicles, do not address rebates, often the batteries have run out, and other such activity not particularly promoting the benefits of electric vehicles. The dealer protection models arose out of Depression level legislation in which at that time the OEMs offloaded retail sales and service to third-party franchises, and in essence the laws at that time, the franchise laws over time, have been used to protect those independent resellers from being placed out of business by the manufacturers coming and undercutting them. And this also would have an anti-competitive practice. So that's the basis, or at least the alleged basis, of the somewhat protectionist legislation. And obviously that was done in the 1930s during the Depression, so we're obviously at a much different time, and maybe the factors should be reconsidered. So in one of my prior videos, I addressed how Tesla had expanded their in-house legal department, and they had expanded it with a really high-quality legal team. And this occurred starting in or about June of 2022. And I believe Elon Musk came out in or about May of 2022 and addressed that he was putting together a litigation team. So the case at issue, and it'll make sense, the timing, the case at issue is called Tesla versus Louisiana Dealers Association, and there's a bunch of other defendants who are either car dealers or the owners of those car dealers. So in or about August 26th, 2022, if you recall again, June was about when they started the hiring of in-house counsel, additional in-house counsel. Tsla and related Tsla entities filed suit in U.S. District Court in the Eastern District of Louisiana against the Dealers Association, the individual car dealers, and the individual car dealers personally. So it has many, many parties. The basic claims of this federal action were federal antitrust violations, violations of the Equal Protection and Due Process Clause under the 14th Amendment of the United States Constitution, a violation of the Commerce Clause, declaratory relief, and some other state claims. The assertion by Tsla is that Louisiana is acting in a protectionist and anti-competitive manner, is not permitting direct sales to consumers, and further, that Tsla asserts that all the named defendants are acting in a conspiracy amongst themselves to prevent Tsla from conducting business in the state of Louisiana. Just out of an aside, in 2016, there was a lawsuit filed by Tsla against the state of Michigan. Eventually, that was resolved, I believe, in 2020, which permitted some direct sales in the state of Michigan. So now we're going back to the Louisiana case. The outcome of that case, especially if the law is made up on appeal, and the point there is only legal precedent is made on appeal. So if a case goes up to a court of appeal, a federal court of appeal, then precedential law is made at that point in time. Or if somehow this matter goes up to the U.S. Supreme Court, perhaps on equal protection or due process constitutional grounds, or perhaps for a violation or impact on the Commerce Clause. And the Commerce Clause is basically where activity impacts interstate commerce. So, for example, crossing state lines. Those might be reasons why a Supreme Court might be interested in taking up a case like this if it ever got that far. But the outcome, whatever it might be, whether it be appellate law or just the law of a U.S. District Court, or if there's some resolution, it may impact the very marketing and profit of Tsla in the future. And I do believe it's also influenced by Tesla's new in-house structure and attitude and their attempt to protect the rights of Tsla and its shareholders. I checked on the court docket today. There is a joint motion to dismiss Tesla's action that will be heard in the next 45 days. So a motion to dismiss is a procedural filing. It's not substantive. It's fairly common, especially in this type of litigation. And so the defendants in this case are challenging the complaint that was filed. There probably will be additional arguments and hearings related to the complaint and filings, and these are purely procedural, not a substantive attack. They are, again, really common at this stage of proceedings, and they are more just arguing and battling over procedure than over what the real issues are in this case. So I would say the case is in its early point of being resolved. It may eventually go to trial, be decided by motion, or may be resolved by negotiation. I will continue to monitor this case and others like it and report them to you. I think the outcome of this and similar cases will be very influential as to Tesla's future in the United States and its profitability. Have a good day. Be well.